And here we go. Welcome back, folks. We're doing it again. We're doing it live. Um, so as you all know, this is something that I covered yesterday for a little bit. So we'll be continuing a little bit today, but this is going to be a bit of a brief stream, really because for a while, but I didn't want to spend too much time on this because I didn't have a whole lot of time to go over these documents. So this will be a little bit. I'm guessing this stream will maybe go probably less than an hour because I just wanted to get to some stuff that I thought was, I guess, somewhat juicy, I guess you could say, but more interesting than anything else, right? So, as I stated yesterday on the stream, there's a lot of filings that are very repetitive. It's just a lot of back and forth as these things tend to go. So there's going to be a lot of repetition in the wording and the language of these documents and stuff like that. So there's not going to be really too many new things in between. So I'm just going to kind of focus on the stuff that I see that is different, you know, because I don't want to do like 2 or 3 streams in a row where I'm just reading documents that sound exactly the same as the previous document. That's something I'm trying to avoid. I'm not trying to, I like getting super chats and I like monetizing my channel, but not to the point where I want to be just padding the channel here with pointless content. So I don't care to do that. So I'm just going to, like I said, go over the stuff that I think is the most pertinent because there's so much of it as it is, and as you would expect in a lawsuit, there's going to be a lot of stalling tactics on both sides. That's just the nature of how these things go. So um with this here, what I'm about to show you now, this is the response, what Delirious's first response, where he was trying to essentially get the um uh, the case dismissed on jurisdictional grounds, which is the right thing to do. But what surprises me is the fact that he didn't file a countersuit, considering, or at least I don't see anything so far that indicates that him or his lawyers have filed a countersuit, because he has grounds too, in my opinion, for at least the defamatory stuff that has been said, right? When we were going over Ohm's initial filing yesterday, remember that a lot of that was stuff that I kept saying over and over again. These are things that Delirious could also claim. These are things that he can also file suit for, if you think about it, especially considering the fact that if we're being honest about the entire situation here, looking at it from what we've seen publicly, Ohm fired the first shot. He can say that he didn't. He could say that he could say whatever revisionist history he wants, but at least in the public sphere, we know, at least from what we've seen, that he fired the first shot. He's the one that started saying this stuff publicly. He's the one that went to Drama Alert. He's the one that mentioned all this stuff first. He fired the first shot. And no amount of him trying to rationalize, no amount of him trying to rewrite the history is going to change that, because that's what everybody saw, right? Delirious didn't go to Drama Alert. He didn't go to Keemstar and do any of this shit. That was all Ohm, right? And if we look at even before that, right, with the drama that Ohm started with Terrorizer and things like that. So everything, even though, like I said, I'm not saying that Delirious is right in this situation. What I'm saying, though, is his response came because of what Ohm initially started. And to say otherwise is just being dishonest, right? Unless, again, there's something else that we just didn't see or that we're not privy to. But as far as I know, at least in the public space, that's the way it happened. That's the way I remember it happening. That's the way it did happen, as far as I know. So it's all good, X Lopez. You're good. I appreciate you being here on a Saturday night, because I know a lot of people are out and about on Saturday night. So hopefully, for those of you that aren't tuning in live, you'll get a chance to see the replay, because I am going to leave this video up. Whenever I do these kind of court case type streams where I'm going over documents and stuff like that, I tend to leave them up for people to be able to reference if they need to, if they just want to see what's in the documents, by pausing the video or whatever, or looking it over for themselves. Now, as I did before with the previous document, I did redact names and stuff like that, even though, again, if you look up this court case, this case number here, anybody will be able to find this, right? You'll be able to find these documents for yourself. If for anybody that wants to go out and search for them, if you really want to know what's in them, it's public record, so you're more than free to do so. And even though, like as I stated before, I'd be well within my right to show everything and not really have to redact anything, just for the sake of not having YouTube come down on me, or somebody decide to get froggy and file a privacy complaint against my video. I went ahead and redacted it. Like I said, it's something I would do regardless, just because of the rules on YouTube. It gives people the ability to just flag whatever whenever. So I'm not trying to have some flag happy people hit this video up. So I did redact the names of Delirious's legal name and obviously Ohm's legal name, even though, like I said, most people probably already know him anyway. So that's where you'll see like blanks like this, where it says plaintiff and defendant and stuff like that. But we know who's being referenced here. So this right here, this was Delirious's response, right? His first response to all this. This is a memorandum of law in support of motion to dismiss complaint for lack of personal jurisdiction and improper venue or in alternative transfer to transfer venue of defendant Delirious by and through his attorney Edwin F. McPherson of the law firm McPherson LLP submits the memorandum of law in support of his motion to dismiss for lack of personal jurisdiction and improper venue or in the alternative to transfer venue. So I'm not too certain about how laws are in North Carolina, if that's like the only other alternative they could do. Like I said, I talked about it yesterday. There doesn't seem to be any anti-slap laws as far as I could find in North Carolina, which would be another way to try to get the case dismissed. So I guess this is just, again, I guess the idea here, at least, and again, I'm purely speculating here and I could be completely wrong about this. I guess the game plan on Delirious's lawyer's parts is that if they can't get it dismissed, they can at least try to see if they can have it tried in North Carolina, where they probably feel that they would have the home field advantage, where they would have, the most easy access to witnesses and things like that. Because as we all know, Cartoons, who is Delirious's real life best friend, also lives in North Carolina. And apparently he has been, he's somewhat involved in this stuff too, because he's one of the people that I would assume would be called to be a witness for Delirious, right? Because he's had his own interactions with Ohm in the past that have not been all that pleasant. So I would assume that that's why, that's the reason why that his attorneys would, if they can't get it dismissed, want it to be basically in Delirious's backyard. They probably believe that there'll be the advantage of, again, having Liz, Delirious's girlfriend, be a witness, things like that, and all that stuff. Maybe they feel all that stuff will be easier if it's handled in North Carolina. I don't know. I can't really speak to their strategy. Like I said, just pure speculation on my point. So I'm going to switch this up real quick because I just want to show that first part of the document. Now we could see the rest, because for some reason it shows up weird on that site where it won't show the links. And I think it's pertinent to show these links that are part of that document. So just give me one sec here, and we're going to fix this right up here, and I'll get this back on screen for y'all. So let's see here. Let's see, where's it at? Where's that PDF? Oh no, here it is. Here we go. All right, cool. All right, so here we go. So this is a discussion. The complaint should be dismissed in its entirety due to lack of personal jurisdiction. Standard of review for determining personal jurisdiction. To maintain the instant action against defendant, the court must have personal jurisdiction over him, and venue must be proper in this court. A defendant may move to dismiss for lack of personal jurisdiction under Rule 12b-2. And once a defendant challenges personal jurisdiction, the plaintiff bears the burden of establishing the district court's jurisdiction over the non-resident. So as you can see, there's court cases being cited here. Now, I'm not going to go through the painstaking effort of going to each one of those because they're already, they're using them to cite. And I think they go ahead and right here, they put the parts that are most pertinent to the argument that they're trying to make here, right? So it says a plaintiff's complaint must plead jurisdictional facts establishing a prima facie case for personal jurisdiction. O'Hare International Bank versus Hampton. That was in 1971. And here's the pertinent part that they're citing in that particular case. It says, although the court must accept all well-pleaded factual allegations, citation omitted, it need not credit conclusory legal allegations. Immediate, and they cite a couple more cases here, right? So this, you see this right here, a couple of different cases that they cite in determining whether personal jurisdiction exists. Affidavits and other materials outside of pleadings may be considered. The Supreme Court has labeled two types of jurisdiction, general and specific, that minimum context can establish. And they cite a couple more cases here that they quote. General jurisdiction permits a court to assert jurisdiction over a defendant based on a formal connection unrelated to the underlying suit. However, general jurisdiction based on business activities is only used to determine where corporate entities can be considered at home. So obviously they're referencing the fact, I presume, that of course Delirious's place of business is going to be from his home, which is in his state of North Carolina. And as we know, Ohmwrecker resides in Illinois. That's his place of business at his home, right? So then we have here, it says general jurisdiction over an individual is only available in the state of a person's domicile. So it says here, due process permits the exercise of personal jurisdiction over a non-resident defendant only when the party has purposely availed itself of the benefits and protections of the forum state by establishing minimum contacts with the state, and when the exercise of jurisdiction over that party would be consistent with traditional notions of fair play and substantial justice. So it says here, specific jurisdiction or case-linked jurisdiction focuses on the relationships among the defendant, the forum, and the litigation. To establish specific jurisdiction, the court only analyzes those contacts from which the cause of action arises. So citing a couple more cases here. In particular, defendant's suit-related conduct must create a substantial connection with the forum state. So in my layman's understanding, it seems like it has to be something that really would what they're trying to part of the argument that's trying to be made here is that it would have to do with like we talked about yesterday, right, in regard to the tortious interference claim and things like that. Things like if Delirious actually owns some kind of business over there in Illinois, maybe had some kind of secondary, maybe if you had some kind of secondary residence there, it would really have to depend on, I guess, barring any kind of him just kind of, what's the word, waiving any kind of rights. It would, I would assume there'd have to be something that would have to have him rooted in the state of Illinois in order for this to have any kind of effect on him. But again, could be completely wrong about that. So it says contacts with the forum may be sufficient to support specific jurisdiction if the defendant purposely avails himself of the privilege of conducting activities with the forum state, thus invoking the benefits and protections of its laws. So they cite the Burger King Corporation versus this person here, 1985. Purposeful availment of the forum state exists when the defendant's conduct and connection with the forum state are such that the defendant should reasonably anticipate being hauled into court there. So I think that's pretty self-explanatory. The requirement of purposeful availment ensures that a defendant will not be hauled into a jurisdiction solely as a result of random, fortuitous, or attenuated contacts or of the unilateral activity of another party. So let's see. Further, in regards to specific jurisdiction, in the Seventh Circuit made clear in advanced tactical ordinance that the mere fact that the defendant's conduct affected plaintiffs with connections to the forum state does not suffice to authorize jurisdiction. The relation between the defendant and the forum must arise out of the context that the defendant himself creates with the forum state. So it says contacts with the forum state, or with the forum created by the plaintiff, I should say, or a third party, are not attributable to the defendant and cannot be decisive in determining whether the defendant's due process rights are violated. So it says here, courts must look at the defendant's contacts with the forum state itself, not the defendant's contacts with the person who resides there. It is not sufficient to rely on a defendant's random, fortuitous, or attenuated contacts, or on a unilateral activity of a plaintiff. 2, defendant is not subject to personal jurisdiction in Illinois. Defendant, as acknowledged and alleged by plaintiff, is a citizen and resident of the state of North Carolina, and is domiciled and lives within the Eastern District of North Carolina. All of the defendant's business is conducted from his home in North Carolina. Defendant has never been a citizen or domiciled in the state of Illinois. In fact, defendant has never visited or so much as set foot in the state of Illinois. Defendant owns no real estate, businesses, or other assets located in the state of Illinois, does not pay taxes in Illinois, or otherwise have any type of business presence in Illinois. So that's key, right? That's what I kind of mentioned beforehand and what I thought they would argue, and it is a good argument to make, right? As we know also, Delirious has never joined any of the Vanoss crew at any of these conventions that they've gone to. He's never been to any of their fan meetups or signings or anything like that. So that's another thing too, right? Because when it comes to the tortious interference claim, that would be another one that could have helped Ohm, right? If it was a thing where Delirious was out there with members of the Vanoss crew going to different conventions, if he decided to, especially, also when it comes to the defamation, right? If he decided to go to, like I use the example of him going to, say, like a place like C2E2, right? One of the biggest, if not the biggest, comic book convention over there in Chicago, Illinois. And he decided to do a panel and was talking trash about Ohm, saying defamatory things about Ohm in front of everybody, then that might be grounds right there for some of the causes of actions that Ohm had brought against him. So we'll continue on here, though. Let's see. Thus, an individual. Okay. So, thus, as an individual domiciled in North Carolina, it is undisputable that general jurisdiction does not exist over defendant in Illinois. With respect to specific jurisdiction, the complaint is devoid of any averments establishing the defendant purposely availed himself of the privilege of conducting business in the forum state or purposely directed his activities at the state. So it says, although defendant does maintain a strong online presence on YouTube and other social media sites, which are viewable anywhere that has an internet connection, none of his videos or businesses are directed in any way specifically to residents of Illinois. Great point, right? Plaintiff's claims all revolve around online statements allegedly made by defendant via one post on social media website Twitter. We see here, but it says here in the seventh, but I'm going to read this real quick, right? The Seventh Circuit made clear that after Walden, there can be no doubt that the plaintiff cannot be the only link between the defendant and the forum, and any decision that implies otherwise can no longer be considered authoritative. So we'll go on here. Media says Twitter complaint. Okay. Emails allegedly sent to YouTube drama channels or comments made on a YouTube live stream. This is when they're referencing the complaints of the document that we looked at yesterday. That's what these are, just for those of you that weren't here yesterday. Or comments made on YouTube live stream, okay, or via direct messaging plaintiffs' followers on Twitter, okay. There are no allegations in the complaint that any of the statements allegedly posted by defendant on Twitter were directed to any Illinois residents, or any allegations that any of the alleged emails or direct messages were sent or received by any residents of Illinois, regardless the mere receipt of or access to any such online statements by Illinois residents would be random and fortuitous and still not constitute sufficient minimum contacts by defendant to establish specific jurisdiction. So then they cite another, what do they say here? Oh, okay, they're looks like they're citing law, the sending of allegedly misleading emails to a list of subscribers that included the forum state, residents, and the maintenance of an interactive website not sufficient to establish minimum contacts. The Seventh Circuit in the advanced tactical case stated that in regards to online activity and virtual contacts, the traditional due process inquiry is not difficult to apply to cases involving internet contacts. The court needs some sort of easier to apply categorical test, quoting Illinois versus Hemi Group, citing Jennings versus AC Hydraulic. It says, although technological advances may alter the analysis of personal jurisdiction, those advances may not eviscerate the constitutional limits on a state power to exercise jurisdiction over non-resident defendants. Thus, our inquiry boils down to this. Has defendant purposely exploited the forum state market beyond simply operating an interactive website accessible in the forum state and sending emails to people who may happen to live there? Has the defendant in brief targeted the forum state somehow? It says here, the answer to these questions is both the advanced tactical case and this case is no. And in this case is no. Okay. The connection between the place where an email is opened and a lawsuit is entirely fortuitous. The interactivity of a website is also a poor proximity for adequate in-state contacts. So this is something I'd mentioned before, right? And this is why this is probably going to be one of those things that will not really one thing I think that the judge will look at and not allowed to necessarily go through. Even the defamation, that's the other thing too. We were saying yesterday that there might be some causes there with the defamation, but defamation is very hard to prove and argue in court. Even if it's out there for everyone to see, right? And the thing is, we have an instance where a guy also engaged in that. So I'm wondering if that's ever going to be brought up by Delirious's attorneys or not. From the filings that I've seen so far, it doesn't seem to be the case. But Ohm could have some causes of action, but it just really depends on how well his lawyers are able to argue it, and if the judge, takes those arguments and finds merit in them. But at the same time, this is stuff that happens a lot. And I mean, personally, look, I think that the whole case is really dumb on both parts, but you never know what could happen. That's the thing. That's the interesting thing about all these cases. It could, the court could end up siding with Ohm. It could end up siding with Delirious. It could get thrown out completely. They could be ordered to just do mediation because the judge just doesn't want to deal with it, right? We'll have to wait and see. Especially, what's going to be interesting to see if there's any hearings and see how those go, which there hasn't been. There might have been some. I have to look through the documents again, but so far, like I said, I think the whole case is pretty dumb. I think a lot of the arguments being made are pretty dumb too, but you never know what they're going to find merit in these cases. So to answer these questions both, all right, let me see. The connection between the place where an email is open and a lawsuit is entirely fortuitous. The interactivity of website is also in poor proximity for adequate in-state context. We have warned that courts should be careful in resolving questions about personal jurisdiction involving online contacts to ensure the defendant is not hauled into court simply because the defendant owns or operates a website that is accessible in the forum state, even if the site is interactive. So this makes sense. The operation of interactive website does not show the defendant has formed the contact with the forum state. And that right there is a strong point right there, right? That the operation of an interactive website does not show that the defendant has formed a contact with the forum state. So, and without the defendants creating a sufficient connection or minimum contacts with the forum state itself, personal jurisdiction is not proper. In this case, all of the subject online posts or comments allegedly made by the defendant took place on Twitter and or YouTube, which are interactive online public websites viewable and accessible anywhere that has an internet connection, and certainly do not constitute sufficient minimum contacts with Illinois to establish personal jurisdiction. Having an interactive website should not open a defendant up to personal jurisdiction in every spot on the planet where the interactive website is accessible. To hold otherwise would offend traditional notions of fair play and substantial justice. Could you imagine that? that'd be hell for anybody, right? If just, based on saying stuff on social media like that, that it would, or at least in regards to tortious interference, that that you'd have to be hauled in to another part of the country, even though you've never set foot there. It's crazy. So let's see. Let's continue on here. Moreover, personal jurisdiction is a claim-specific inquiry, and a plaintiff bringing multiple claims must establish specific jurisdiction for each claim. So it says here, plaintiff has alleged 5 separate claims against defendant, which all revolve around the same alleged online internet posts, comments, messages, and or emails, and are not sufficient to establish specific jurisdiction. Additionally, in regards to plaintiff's claims for tortious interference with protective economic advantage beyond a few additional vague allegations of defendant allegedly contacting at least one sponsor, several video game streamers, and many plaintiff's followers. And this is what I was saying yesterday. This is probably the part that interests me the most about this lawsuit, is the tortious interference part, because that's going to be, I think, pretty hard to prove unless, he has some smoking gun behind the scenes. He has some kind of documentation that could prove it. This is one of those this is one of the ones that I think is going to be dismissed. One of the causes of actions that's not going to go through, but I could be completely wrong. And maybe he does have something, but, I think, unless he's got like signed affidavits from people that are willing to perjure themselves saying otherwise, as well as any of these companies, speaking on that behalf as well, I don't think this is going to go anywhere. But we'll see here. At least one sponsor, several video games here. Okay, so there are no allegations establishing that any of these alleged contact parties were residents of or headquartered in Illinois. In fact, plaintiff has alleged no contacts whatsoever by defendant with Illinois to establish specific jurisdiction as to any of his claims. Accordingly, defendant is not subject to specific or general jurisdiction in Illinois. The complaint should also be dismissed for improper venue, or alternatively, the case should be transferred to the Eastern District of North Carolina. So let's continue. Standard of review for establishing proper venue under Rule 12b-3 of the Federal Rules of Civil Procedure, which instructs the court to dismiss or transfer a case if venue is improper or inconvenient in the plaintiff's chosen form. A defendant may challenge the appropriateness of the plaintiff's chosen venue at the outset of a lawsuit. So we had Black versus City of Newark cited here. Let's see, section 1406A sets forth that the district court of a district in which is filed a case laying venue in the wrong division or district shall dismiss it, or if it be in the interest of justice, transfer such case to any district or division in which it could have been brought. For the reasons set forth below, the court should dismiss the action under section 1406A, or in the alternative, transfer the case to the Eastern District of North Carolina pursuant to sections 1406A or 1404A. Venue. So here's the next one. Venue is improper in this district. Section 1391A L sets forth that the section shall govern the venue of a civil action. Venue of all civil actions brought in district courts of the United States. 28 U.S.C. 1391A L emphasizes that in section 1391B sets forth that the civil action may be brought in L, a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located, a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of property that is the subject of the action is situated, if there is no district in which an action may otherwise be brought, as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. Venue statutes such as section 1391B are designed to protect the defendant against the risk that a plaintiff will select an unfair or inconvenient place of trial. So we have a couple more citations here. As this court noted in Vanguard, the convenience of the plaintiff is irrelevant to the assessment of where the venue proper lies under 1319 or 1391B. And it says here, additionally, section 1391C, in connection with establishing residency for venue purposes, sets forth that L, a natural person, shall be deemed to reside in the judicial district the person is domiciled. In this case, defendant is an individual who is domiciled and resides in the state of North Carolina, specifically in the Eastern District of North Carolina. Accordingly, pursuant to section 1391BL, the Eastern District of North Carolina is clearly a judicial district in which any defendant resides, and all defendants are residents of the state of North Carolina, in which the district is located. Because defendant resides in North Carolina, this district is appropriate venue only if a substantial part of the events or omissions giving rise to the suit occurred here, which is not the case. Okay. So take a breather there for a moment. This is going to be, oh man, this is going to be, this is already pretty long and drawn out as it is, but don't worry, we'll get to the good stuff here, because I'll give you a sneak preview for the next part that we're going to do here in a moment. And that is Ohm's attorneys withdrawing, his first attorneys, because he still has attorneys for this case. His case is still happening, but his attorneys withdrew, and we'll get into why that was, or we will speculate as to why that was, because we don't have a specific reason, at least it was outlined. But I thought that was interesting and something worth mentioning. So let's continue on here. To the extent that any of the subject statements in plaintiff's complaint were made by defendant, such statements would have been posted online and are written by defendant from his home in the Eastern District of North Carolina and not in Illinois. Further, with respect to plaintiff's tortious interference claim, there's not a single allegation that any of the alleged contacts or parties alleged contacted have any connection to any venue in the state of Illinois. To the extent that any alleged contacts that plaintiff purports constituted tortious interference were made by defendant, any such contacts would have been initiated by defendant from the state of North Carolina, accordingly pursuant to section 1391B2, the Eastern District of North Carolina, and not the Northern District of Illinois, is the judicial district in which a substantial part of the events or omissions giving rise to the claims occurred. So this is your conversely, allegations that the venue proper in this district pursuant to 28 USC 1391, because many of the acts giving rise to plaintiff's claims occurred in this district. Complaint 6 is nothing more than conclusory allegation with no factual support whatsoever, although the court must accept all well-pleaded factual allegations cited, omitted. It need not credit conclusory allegations. Thus, plaintiff's complaint should be dismissed for proper venue. So one thing I also want to point out about this stuff and that I find interesting, a lot of times with these initial filings, you'll see people actually use the tweets or screenshots of the tweets like that as proof in these. I'm surprised that nobody's used anything as proof yet. Maybe it's just maybe it's not something that these particular law firms do. Maybe they just, I don't know if there's an added cost for doing stuff like that. But it's surprising that, given the fact that Ohm is a person that has, well, both of them, I would say, have both habitually saved screenshots of a lot of different things, that they didn't decide to put them in any of these filings. But maybe that's something that'll show up in later filings. I don't know. Or maybe I just haven't seen them yet. Oh, thank you, Dev with the 5. Appreciate it. Well, this is getting interesting. Why did some of his lawyers quit? I missed a bit. Sorry. No. I haven't gotten to that part yet, Deb. You haven't missed that part. That's going to be the next part. And that's going to be much shorter than this part, because I'm not going too long tonight. I'm only going for maybe at most an hour, or a little under an hour, because I might stream for a little bit later, stream a game later. I haven't decided yet, or I'll continue on tomorrow. But actually, you know what? Let me do this for now. For those of you that are here, I'd greatly appreciate it, because I'm trying to get this channel, monetized at some point. But I'd appreciate it if any of you in the chat haven't already, you can subscribe to that channel. That's my other channel. I'm going to try to get to streaming on there, doing some gaming streams and stuff like that, and trying to get some more gaming content on that particular channel. But let's continue on here with this, though. Let's get back to this. Let's get back to the good stuff. So, conversely, plaintiff's allegation the venue, let's see. Okay, yeah, we're out there. Conversely, plaintiff's allegation the venue is proper. Is need not. Okay, no, okay. Alternatively, this case should not be transferred to the Eastern District of North Carolina. So, obviously, they just want an outright dismissal. But again, like I said, what they're going for here is if they can't get an outright dismissal, they at least want it in their own backyard. Because I guess they feel there'll be some kind of advantage if they do have it in North Carolina. So, at least for his side. So, in addition to the remedy of dismissal, Section 1406A also sets forth that if it be in the interest of justice, the court may transfer such case to any district division in which it could have been brought. As set forth above, it is clear that the Eastern District of North Carolina in which defendant resides is the proper district in which the case could and should have been brought. Additionally, Section 1404A sets forth that for the convenience of parties and witnesses in the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought, or to any district division in which parties have consented. So let's see. A Section 1404A motion to transfer venue requires a three-step analysis. The movement must establish the venue is proper in a transfer district. The venue is proper for in the transferee district, and the transfer of the case would serve the convenience of parties and witnesses in the interest of justice. So yeah, like I said before, they probably feel that, okay, if we can't get it dismissed, at least if we have it here, we already have a couple of witnesses here. That'll make it easier for them, right? If they have to show up. As detailed above, there is no question that this case could and should have properly been brought, if at all, in the Eastern District of North Carolina. The next step of the analysis is that the district court must weigh private interest factors and public interest factors to determine if the proposed transferee venue is clearly more convenient than the current venue. Then they cite a couple of other cases. The private interest factors are the plaintiff's initial choice of forum, the relative ease of access to sources of proof, 3, access to witness and witness attendance at proceedings in light of the availability of compulsory process and the cost of obtaining the attendance of witnesses, the status of materials events, and the convenience of the parties. So yeah, it looks like that's exactly what they're thinking with the filing. So while these factors are useful, it permits a flexible and individualized analysis and efforts, and affords district courts an opportunity to look beyond a narrow or rigid set of consideration in their determinations. The public interest factors are relative docket congestion and likely speed to trial. Each court's relative familiarity with the relevant law, the respective desirability of resolving controversies in each locale, the relationship of each community to controversy. The private interest factors weigh in favor of transfer. Plaintiff's choice of a forum should be given little weight. While the plaintiff's chosen forum generally is afforded deference when considering whether to transfer venue, citation omitted, the plaintiff's choice of forum is not absolute, and the chosen forum must bear some reasonable relationship to the events that form the basis of the action. When the chosen forum lacks any significant connection with the case, the plaintiff's choice becomes merely one of many factors the court may consider. Man, his attorneys used a lot of damn citations. Holy shit. When the events given rise to the cause of action took place elsewhere, the weight granted to plaintiff's choice of forum is diminished significantly. Detailed in prior sections, the event giving rise to the lawsuit took place in the Eastern District of North Carolina, not Illinois, so the importance of this factor is diminished significantly. The ease of access to sources of proof and the availability of the compulsory process to secure the attendance of witnesses weigh in favor of transfer. Given the defendant resides in North Carolina, it is logical that the vast majority of the evidence, including but not limited to all the relevant documents relating to plaintiff's claims, are maintained in the Eastern District of North Carolina. Moreover, the convenience of non-party witnesses is often viewed as the most important factor in the transfer analysis. And we have more citations here in evaluating the availability of compulsory process in Section 1404A transfer. The court must determine whether the non-party witnesses reside within the subpoena power of either the transferor or the transferee court. So, like I said, I'm pretty sure that his witnesses, Delirious's witnesses would first and foremost be someone like Cartoons and his significant other, maybe a few other people, who knows. But I would think that they'd be the ones that are most relevant to this case, because they're the ones that have had these public interactions as well, right? So we have here, in this case, the only non-party witness specifically identified in plaintiff's complaints is Liz Katz, whom plaintiff alleges to have assisted defendant and confirmed the use of fake profiles by defendant, as alleged and acknowledged in plaintiff's complaint. Ms. Katz is defendant's girlfriend. More importantly, Ms. Katz, who lives with defendants, is also a citizen and resident of the state of North Carolina and is domiciled and lives within the Eastern District of North Carolina. Thus, she would not be within the compulsory power of the state of Illinois to attend depositions or hearings. Any deposition or hearing subpoena from this court to a non-party witness such as Ms. Katz cannot issue if the witness will have to travel more than 100 miles to comply. And in this case, Ms. Katz would have to travel more than 650 miles, which would also make any necessitated case related travel by Ms. Katz extremely inconvenient and expensive. A trial subpoena well, come on, let's be honest here. They could afford it. They could afford it. But you know, lawyers are going to make these kind of arguments, obviously, that it's an inconvenience for these witnesses. I mean, but you know, if we're being honest here, obviously they can afford it. Let's see. A trial subpoena of non-party witnesses may not issue if the witness will incur substantial expense to travel to the hearing. Moreover, plaintiff does not identify any witnesses located in Illinois, let alone the Northern District, other than himself. That's a fair point. Furthermore, in connection with plaintiff's tortious interference claim, plaintiff only vaguely references entities with which defendant supposedly knew plaintiff had business relationships. Notably, not one of these alleged entities is incorporated or headquartered in the state of Illinois. However, one of them, Epic Games Incorporated, is headquartered in Cary, North Carolina. See request for judicial notice. Thus, to the extent any documents related to plaintiff's tortious interference claim would be needed from Epic, such documents would be more easily accessible within the compulsory subpoena power of North Carolina. Accordingly, the second and third private interest factors weigh in favor of transfer. Okay, so they just threw down the gauntlet there and are like, hey, all right, if you got something in writing that says that, well, hey, show it, or we can go ahead and subpoena for it. So then we have the status of the material events weighed in favor of transfer, previously detailed to the extent of any of the subject statements in plaintiff's complaint were made by defendant. Such statements would have been posted online and are written by defendant from his home in the Eastern District of North Carolina, not Illinois. Further, with respect to plaintiff's tortious interference claim, to the extent that any alleged contacts of plaintiff reports constituted tortious interference were made by defendant, any such contacts would also have been initiated by defendant from the state of North Carolina. Moreover, at least one of the third-party entities vaguely identified in plaintiff's complaint in connection with his tortious interference claim, Epic Games, is also headquartered in North Carolina. Accordingly, this factor also weighs in favor of the transfer. The convenience of the parties, both parties are in the same line of business, working as online game commentators and internet personalities that produce and publish videos on streaming sites of themselves and others playing video games. They would arguably experience similar inconvenience to travel to the other form of deposition and or trial, with similar inconvenience to their work schedules and financial hardship. Thus, the private interest factor of convenience of the parties is at least neutral. I like how they say, financial hardship. I don't think it would be that much of a financial hardship for either one of them, but of course, I mean, we all know that. It is what it is. The public interest factors. Public interest factor of familiarity with relevant law favors transfer. The first of the public interest factors, docket congestion, is at the very most neutral. As this court is well aware, the Northern District of Illinois is one of the busiest federal courts in the country. In any case, the second factor, consideration of the familiarity with the relevant law in connection with the requested relief, favors transfer. In this case, plaintiff is seeking injunctive relief from defendant, which would require enforcement in the Eastern District of North Carolina, where defendant resides, and thus the application of North Carolina law, the enforcement of injunctive relief, another state and district favors transfer. Let me see. More citations. Okay, then we have the public interest factors of local interest favors transfer. Finally, the third and fourth factor, local interest in the relationship of each community and to the controversy, which are factored together, heavily favored a transfer to the Eastern District of North Carolina, as previously detailed. The status of material events in the Eastern District of North Carolina and not in Illinois. Moreover, the only alleged third-party witness, Liz Catt, resides in the Eastern District of North Carolina and is at least one of the third-party entities vaguely identified in plaintiff's complaint in connection with this tortious interference claim. Epic Games is also headquartered in North Carolina. Accordingly, any alleged interference with plaintiff's contractual relations with Epic would have taken place wholly in the state of North Carolina. Thus, North Carolina has a particularized local interest in the dispute, while Illinois has no interest whatsoever. For all the foregoing reasons, defendants respectfully request that this court enter an order dismissing all of the claims against them for lack of personal jurisdiction and or improper venue, or alternatively, in order transferring this case to the Eastern District of North Carolina. And there we have that. So we are going to, so that was the response by the Delirious team to try to have this dismissed. Like I said, I'm surprised that no countersuit. There's no countersuit that was filed. Now we're going to bring up the next bit of stuff here, which I think you guys will find interesting. This is one that this is the one you all have been waiting for, and after this one, we'll go ahead and wrap up the stream for tonight. But this right here, I thought was pretty interesting because if you notice, Ohm hasn't been as he hasn't been as vocal the last I would say the last couple months, right? And that's because this was filed, as you can see, this was filed around October, okay? And it seems like he's quieted down a bit, and I think this is probably why. We're going to go over this. So this is a motion to withdraw as counsel for plaintiff, okay? So this right here says, now come Thomas A. Christensen, Alexandra N. Presner, and Huck Boma PC, collectively Huck Boma, as counsel for of record for plaintiff Ohmwrecker, and hereby move this court pursuant to LR 83.51.16 to enter an order permitting Huck Boma to withdraw as counsel of record for plaintiff in support of their motion. Huck Boma states as follows. 1. Huck Boma are attorneys for plaintiff in the above captioned matter. Huck Boma has grounds to withdraw as counsel pursuant, and we're going to go over with this law, the law that they're referencing here. I'll go over it in just a moment. And then, like I said, we can, unless it says it specifically here, but we can kind of speculate as to why his attorneys decided to withdraw, right? So it says, Huck Boma has given due notice to plaintiff of this motion and their decision to withdraw from representation. So this right here means that they're the ones that decided to withdraw, right? They told him, hey, we're out. You know what I mean? There's no other way to infer that, right? We're giving you notice. We're out of here. Okay. No trial has been set in this manner. The granting of this motion would neither be inequitable nor serve to prejudice any party or proceeding in this matter. In the event plaintiff does not appear at this time, at the time this motion is granted, either in person or by substitute counsel, then within 3 days of the entry of the order of withdrawal, a copy thereof will be served upon plaintiff by Huck Boma, and proof of service will be made and filed. Wherefore, Thomas A. Christensen, Alexander N. Presner, and Huck Boma PC respectfully pray this court grant their motion and enter an order granting Thomas A. Christensen, Alexander N. Presner, and Huck Boma PC to leave our PC leave to withdraw as counsel for plaintiff and henceforth to cease representing plaintiff. Okay, so this law that they're referencing here, the LR 83.51.16B, I'm going to go ahead and read that to you right now. Actually, you know what? I'll just show you all. We'll look it over here so you guys can see for yourself. Okay. So here we go. Let's go ahead and bring that up here. So this is the Northern District of Illinois, United States District Court, their local rules, declining or termination of representation. So it says under A here, it says, so they cite B, but these are some of the ways that they could get out of it, right? A lawyer representing a client before a tribunal shall withdraw from employment with permission of the tribunal if such permission is required. And a lawyer representing a client in other matters shall withdraw from employment if the lawyer knows or reasonably should know that the client is bringing the legal action, conducting the defense, or asserting a position in the litigation, or is otherwise having steps taken merely for the purpose of harassing or maliciously harming any person. Now, let me make this clear. It's not under A, right? It would have been interesting if they would have cited A, though, right? Because they could have, cited A and then one of these. Could you imagine? It'd be crazy. So the lawyer knows or reasonably, okay, let's see, the number, number 2 would be the lawyer knows or reasonably should know that such continued employment would result in violation of these rules. Number 3, the lawyer's mental or physical condition renders it unreasonably difficult for the lawyer to carry out the employment effectively, or 4, the lawyer is charged by the client. Okay, so here we have B, right? It says here, except as required in Section A, a lawyer shall not request permission to withdraw in matters pending before a tribunal, shall not withdraw in any other matters unless such request or such withdrawal is because the client, insist upon presenting a claim or defense that is not warranted under existing law and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. B, seeks to pursue an illegal course of conduct. Interesting, right? Insist the lawyer pursue a course of conduct that is illegal or that is prohibited by these rules. By other conduct renders it unreasonably difficult for the lawyer to carry out the employment effectively. E, insist in a matter not pending before a tribunal that the lawyer engage in conduct that is contrary to the judgment and the advice of the lawyer, although not prohibited by these rules, or substantially fails to fulfill an agreement or obligation to the lawyers as to expense or fees. Let's see. Then under 2F, it says here, the lawyer's inability to work with co-counsel indicates that the best interest of the client likely will be served by withdrawal. And then we have the client consents to termination of the lawyer's employment after disclosure, or the lawyer reasonably believes that a tribunal will, in a proceeding pending before the tribunal, find the existence of other good cause for withdrawal. Then we have if permission for withdrawal from employment is required by the rules of tribunal, a lawyer shall not withdraw from employment in a proceeding before the tribunal without its permission. In any event, a lawyer shall not withdraw from employment until the lawyer has taken reasonable steps to avoid foreseeable prejudice to the rights of the client, including giving due notice to the client, allowing time for employment of other counsel, delivering to the client all the papers and property to which the client is entitled, and complying with the applicable laws and rules. Well, that sure as hell didn't happen. A lawyer who withdraws from employment shall refund promptly any part of the fee paid in advance that has not been earned. So I don't know which specifically is entailed here under B, right? But it's got to be, I would assume it is it's one of these, right? Because that's what's cited in the document. It's one of these, take your pick. I don't know specifically which one. Maybe all of them. I don't know. But basically, they could have just left it. Well, even then, well, actually, if we go back to the document, it could have even been I think they cited under B initially, but then like they kind of leave it open here. Let me go back to it real quick to show y'all. So I don't know. I can't say we could only really speculate as to what the specific reason was, why they decided to withdraw counsel. But if you think about it, yeah, see right here, they do it as pursuant to B. They get a little bit more specific here. So it's got to be one of those. Maybe more than one, for all we know. I mean, if you think about none of them are good. Exactly what Dev said. None of them are good regardless. They're all pretty bad. But if you think about it, right, when there's a court case going on, lawyers want you to be quiet. They don't want you to say anything publicly. And maybe, and this is just pure speculation. I don't know this for a fact, but I'm sure that Ohm didn't help himself with a lot of the stuff that he decided to say publicly, because I'm sure that his lawyers were keeping tabs on him and what he was doing. But yeah, what Dev said is correct. Yeah, none of them are good, right? Whichever one is the case as to why, none of these are good reasons. So who knows? It could have been a matter of could have been a matter of money, could have been something else. Don't know. But they're the ones that decided to withdraw. I don't see anything that indicates that he's the one that said, hey, I could get better lawyers that could do a better job. It seems like they're the ones that initiated the action. Maybe they felt that, look, this is not going to go anywhere. Or maybe they felt that there was just stuff that Ohm was doing. Who knows? Like I said, all that is things that we could just speculate on. There's no way for us to know for certain, but they obviously felt some kind of way. And it like I said, it might be one of these. It might be several of these. So at this point, we could really only speculate unless they get really, really specific. Because like I said, under B, this is all that's under B right here. So, yeah, his initial lawyers are out. He does have a new legal team that picked up the case for him. So he's not without representation. He does have representation. They didn't quit. The lawsuit is, that's still happening. It just the ones that he initially filed the lawsuit with, they dipped out. They tagged out. They said, peace. So they have their reasons. So maybe that'll come out at some point in time. Maybe we won't find out ever. But with Ohm as a client and with his tendency to not keep his mouth shut, I wouldn't be surprised if that had something to do with it. But we won't ever know for sure. And I doubt Ohm would ever cop to what exactly it was that was the final straw for his attorneys dipping out. His first set of attorneys dipping out, because like I said, he still has representation. So we're not going to misinform anybody here and say that he doesn't have any lawyers. He does have new representation. But his original representation for this lawsuit dipped out. And that, to me, I don't know if that's going to play a factor in these proceedings going forward, if that's going to be something that Delirious's lawyers are going to use this as some means of attacking with. Maybe not. It's hard to say what his lawyer strategy is, because again, I'm surprised they didn't file a countersuit from the very beginning, because a lot of the stuff that is being said by Ohm too, that was publicly said by Ohm and was said first, was pretty defamatory too. And he engaged in some pretty heinous stuff too, despite how he might make things seem. Thank you, Gigi, for the 5, man. Appreciate it, brother. Ohm's lawyers basically, Your Honor, our client is a dumbass, therefore we must withdraw. Maybe, yeah. Yeah. Possibly. Yeah, it's just like, the thing is, look, yeah, who wants to be Ohm's lawyer? Yeah, I mean, look, stuff like that, you're just making it more difficult for your attorneys when you speak. The best thing to do is just let them do their jobs. Let them do what you're paying them for. Let them handle that. Ohm is a person, he has to always respond. And that's been something, again, that's been something I've been critical about, because I think that's something that ultimately hurts him and hurts his cause, is that he responds to every little inconsequential thing. He always has to respond. Even stuff that people are saying, it's just like, dude, that shouldn't even matter. You know, that's a random person calling you such and such thing, or saying that you're lying, because it's like, that's not, that shouldn't be something you should be looking for or wasting your time on. Just let your attorneys handle everything, and you just sit back and chill out. Unplug from the internet, man. Especially if you're a person like Ohm, who claims to have issues, right? And has anxiety issues, then why are you doing something that's going to cause your anxiety to get worse by constantly being online, worrying about what people are saying about you all the time? Just unplug for a bit, man. Just go take a break. Like I said, you're paying your attorneys to bring this court case up and work on it. Just let them handle it, and go take a nice little extended vacation, or just continue making your videos and just drown out the noise. Don't even pay attention to the noise. So I'm going to go ahead and wrap it here, though. I appreciate each and every one of you joining me. Gigi and Dev, you all are the stream daddy and stream mommy. I appreciate you all. I appreciate each and every one of you joining me. I'm going to try sometime this week to go over the next document. So be on the lookout for that. Like I said, subscribe to my other channel too, because I might be doing something on there either today or tomorrow, maybe like a gaming chill stream or something like that. But either Monday or Wednesday, or sometime in this early week coming up, I'll go over the next set of documentation and see where things are. Like I said, I'm going to go over the stuff that's a little bit different, so that we don't tread old territory, like I said, because a lot of this shit is really repetitive and it's really fucking boring. And it's just it's a lot of it is really dumb. I got to be honest. It's a really, at least the Zero versus Jisoo lawsuit had some good stuff in it. There was drama in that. You know what I mean? There was some high drama in that because of the crazy lies and exaggerations that Jisoo made in some of her filings. That made it pretty entertaining and laughable. This stuff is just cringe, and it's really dumb. So like I said, I'm just going to go over the stuff that I feel is different enough that's worth talking about, because I don't want to waste y'all's time with the same shit over and over again. So, and truthfully, I don't want to waste my time with the same shit over and over again. So I'll look through the documents a little bit more and see what comes out that is different. If any new arguments are made, if there's any countersuing that is brought up, and that's the stuff that we'll focus on. We'll focus on the stuff that's different. But yeah, we'll go ahead and wrap it here. Again, appreciate each and every one of you joining me tonight. It's been fun. You all have a fantastic night, and I'll catch you on the next stream. And yeah, sub to the other channel, because I might be streaming on there either later today, or I might just do it tomorrow. But also make sure that you're following on Twitter, because that's where I also announce these streams. So you all have a fantastic night. Enjoy the rest of it. All right. You all take care.